Hello and welcome to BYJU'S Exam Prep IAS. The big news for today is that the Supreme Court has dismissed the ban put on by the Government of India on MediaOne news channel. As you know, MediaOne is a Malayalam language news channel which was banned by the Government of India's Information and Broadcasting Ministry last year on the reasons of national security. This news channel since then had been going to the judiciary time and time again. They first went to the Kerala High Court that refused to dismiss the ban put in by the Government of India. However, now the Supreme Court has dismissed the ban, saying that there is no particular reason that can justify such a ban. In this video of the big news, we will be discussing what is the ban all about, what are the laws that allow the Government of India to put such a ban, and what is this exact case all about. Now, as you can see, the Supreme Court finally has given relief to the MediaOne Malayalam news channel. Earlier, a few weeks back, Supreme Court had first put a stay order, and they were still hearing the petition from the side of the government and from the side of the news channel. Now, they have taken the final decision to reverse this ban on MediaOne. The Supreme Court said that this renewal of broadcasting license of Malayalam news channel, which was stopped by the Government of India on ground of national security, does not hold good for any reason. The Chief Justice of India, who was leading this bench, said that national security claims cannot be made without any reason. The Government of India must give specific reasons why does it believe that this news channel is harming the national security of India, and how is this news channel threatening the public order in the country. As I said, Kerala High Court earlier was hearing this matter and they had refused to set aside the decision of the Government of India, and that is how the case went to the Supreme Court. The Supreme Court has said that the Government of India has not disclosed any reason why is it that they think that national security of the country is being harmed by this one particular news channel. The Supreme Court said that if a news channel can be banned just for criticizing the government policies, that will mean that it is going against the freedom of speech. The Supreme Court said for a robust democracy to exist, freedom of speech, specifically for press, has to be maintained, and the judiciary has to play an important role in preserving that right. This was the full quote given by the Supreme Court of India. The court said, an independent press is vital for the robust functioning of a democratic republic. Its role in a democratic society is crucial, for it shines light on the functioning of the state. The press has a duty to speak truth to power and present citizens with hard facts, enabling them to make choices that propel democracy in the right direction. Now, as you would all know, the freedom of press is not explicitly mentioned in the Constitution of India. If you look at the fundamental rights in Part 3 of the Constitution, you will not specifically find freedom of press being mentioned anywhere. However, the Supreme Court has time and time again said that freedom of press has to be considered as an implicit part of Article 19 only. As compared to this, the American Supreme Court specifically mentions the freedom of press as one of the fundamental rights in the Bill of Rights, but that is not the case in India. So it is not mentioned in the Constitution, although it is considered as a part of Article 19. Now, the Supreme Court, while hearing the matter, was also critical of how the Kerala High Court had handled the matter. Supreme Court had said that Kerala High Court had asked for a response from the central government in a sealed cover. Now, sealed cover basically means that a letter or a physical copy will be submitted of the affidavit by the central government, where central government would specify what are the reasons based on which they have decided to ban this news channel. Now, when such kind of an information is given in a sealed cover, that means it is not open to public. The Supreme Court said that this practice should not really be followed on a large scale. When information is given in a sealed cover, that means you are taking away the right to information from other people who are involved in the case. And thus the Supreme Court said this sealed cover practice infringes on the principles of natural justice. Now, it would also be right to remind you here that it was the Supreme Court of India only that started this practice of sealed cover. In the past few years, the past few Chief Justices have made it a habit that whenever they ask the government to submit certain affidavit, they ask the government to submit it in a sealed cover, meaning that only the judges will read it and no one else will have the privilege of reading what is written in that affidavit. If you look at the background of this case, this goes back to last year. It was in Jan 2022 that the news channel was taken off air because when they went to the Government of India's Ministry of Information and Broadcasting to renew their license, the government denied them the permission, saying that they are a security threat. After which they went to the Kerala High Court. There was a single judge bench in the Kerala High Court that upheld the decision of the INB ministry. After which this was appealed in the division bench of the Kerala High Court. So there were multiple judges that heard the case once again, but again they took the side of the government of India only. This is where the matter finally went to the Supreme Court of India. Now, in all this news and debate, we also have to focus on what exactly are the powers of I and B ministry. Now, until 2021, the Ministry of Information and Broadcasting had the powers to regulate content across all the sectors, which included TV channels, newspapers, magazines, even theaters that play movies, etc. In Feb 2021, the Government of India released the IT rules, which extended its regulatory power over internet content as well. You would have seen how before 2021, all the content that was showed on these apps such as Netflix, Amazon Prime, etc., they were not really regulated by any government authority, but the government believed that they also have to be regulated in certain way, and this regulatory power was given to the INB ministry only. Now, what are their powers exactly? Let's discuss them on a case-by-case basis. So for movies, when they have to be released, they need a certification from Central Board of Film Certification in order for that kind of a movie to be played in the theater. This certification usually tells what is the kind of audience that can watch this movie. For example, A, UA, based on that, certain age groups may or may not be allowed to watch that movie. Also, the power to withhold these films also lies with the INB. For TV channels and OTT content as well, the Government of India has given such power to the INB ministry. Also, if there is a viewer who thinks that a certain channel on TV or certain OTT platforms are not abiding by the guidelines or are showing some content which is against national security, they can also then complain to the concerned authorities. They may first complain to the self-regulatory body within the industry, and finally they can also take up the appeal to the INB ministry as well. This is how the INB ministry has the final say in case of TV channels and OTT platforms as well. Similarly, with respect to print media and website related articles, we have something called the Press Council of India, on the basis of whose recommendation the government can suspend its advertising on any publication. In fact, the INB ministry even has a power to ban certain websites based on the kind of content that they publish. So it would not be wrong to say that INB ministry holds most of the cards when it comes to deciding which TV channel, news channel or print media would be allowed to publish news in the country. Now, is there any specific law about it? Not exactly. There is no specific law that talks about what is prohibited and what is not prohibited. This is what gives a lot of power to the Government of India to decide on a case-by-case basis. So usually, they can take action against these print houses or publications on the reasons of the fact that it is going against the security of the state, it is against public order, it is against public decency, morality, or it is endangering India's relationship with a foreign state. However, there is no specific law about it, and that is why these kind of cases where the government decides whether or not to allow certain news channel to continue to exist, these cases usually go to the Supreme Court time and time again. In this matter also, Supreme Court has finally decided to take the side of the media channel over the Government of India. This is it for today's big news video. Thank you so much for watching. Have a good day ahead. Jai Hind.